Now let's go to our first caller, Bonnie. This is Roger Riedmiller of Lori on the Line. How can I help you?
I was injured in an accident a while back through no fault of my own and did retain an attorney. After a while, a demand letter was sent on my behalf to the other insurance company. They have now responded with an offer which is less than half of what the demand letter was for. And I guess just generally I'm trying to decide, do I accept this offer of settlement or do I wait? I'm just not sure what to do at this point.
Well, okay. Anytime you attempt to negotiate a personal injury settlement, it's really fact intensive. The insurance companies look at who you are, what the nature of your injury is, hopefully look at the facts of the accident, and come hopefully to some logical decision as to the value of the claim. Typically, insurance companies will set a reserve aside, which is basically a hypothetical sum of money which caps the total loss or value, I should say, that they have on the claim. Now, typically when insurance companies make the first offer in response to a demand submitted by a lawyer, usually, but not always, that first offer has some room in it. What I mean by that is that they're not offering, usually their first offer is not the only offer that they're going to make. They're not offering their final dollar. Usually they will negotiate, sometimes it'll go back and forth 2 or 3 times. But it really depends on the value of your case, which is based upon the facts of your situation, not anybody else's. You will talk to a lot of different people and get a lot of different advice as to the value of your claim based upon their experience. Well, unless they have the exact same set of circumstances that you have, they can't tell you what the true value of your claim is because they are not you. They didn't have the same exact injury. They are not the same age, etc. There's just so many factors that go into this process of settling a personal injury claim that is very hard to compare with absolute certainty the value of 2 different cases. So when you ask somebody else what the value of a claim is, you really are only getting kind of a general yard marker range, if you want to call it. You can't really use that as a certainty to value your own claim. What I would suggest that you do, Bonnie, is talk with your lawyer, and they're the best ones to tell you what you should or shouldn't do in negotiating the claim. Ultimately, when the insurance company says, okay, this is our bottom dollar, our top dollar, I should say, this is as much as we're going to offer, you're going to have to make a decision whether you accept that offer or whether you want to try the case. You want to go to trial and let a jury decide the value of the claim. But you don't want to make that decision yet, not when you have just one offer from the insurance company. I strongly urge that you talk to your lawyers. If you feel that they're competent in representing you and they're good communicators with you, then have a sit down with them. Go to their office, sit down and talk with them about what the value of your claim is. Have them explain that to you. And if they have all of the facts properly assessed in their head, in their demand, with a conversation with you, then they should be able to have a meeting of the minds with you as to what the value of the claim is ultimately and get the claim settled for a reasonable sum of money. So I don't suggest that you talk to anybody other than your attorneys at this point in time. And then, of course, like I said, eventually you're going to have to make a hard decision whether you accept the final offer from the insurance company or you litigate the claim in court.